he's in Florida. He reached out to me because he had a brother who passed away in Livonia. The brother, his only asset was his house. He did have a will. So all we had to do was get the court's permission to sell the house. Well, my client in Florida got COVID and ended up passing away from it. So now his wife has to come in and take over as the personal representative for her brother-in-law. So you have to get the court's permission to switch personal representatives. You have to get the court's permission to sell the house. It's been 9 months. We finally just sold the house. He died last year in August, and his brother died in March of that year. So it's some of the delays were because of that, and there's no way we could have avoided that. But if they had both had trusts, it might have taken less time to sort all that out. So that's just a practical example of what could go wrong.
Question?
Yeah.
Could you explain just very simply what probate is?
Yeah, so we have different courts for the county. So in Wayne County or Oakland County, you have the circuit court, you have district courts for each city. The circuit court is where you have civil litigation over $25,000. You have felony cases handled there. And probate court is where you have family matters or estate issues resolved. And so a probate, when something goes through probate, that means it's being overseen by a judge. And they're looking at decisions that are being made and then approving or denying those decisions. They could be in charge of who ends up having custody of your children. They can remove people from custody if they're not doing a good job or haven't met the standard. If they've used the resources they've been entrusted to in a conservatorship inappropriately, they can be forced, the judge can force someone to pay money back. So they have a lot of power over people. And there's a judge, I'm not going to say who it is, but there was a judge in Wayne County Probate Court who took somebody's kid away from them because he gave him a Mike's Hard Lemonade at a Tigers game by mistake. Didn't realize it had alcohol in it. She took his kid away from him and put him in foster care. Didn't even put him with his mom. So it's ideal to avoid that process if you can. Most issues that go through probate through a will are not that complicated, not contested, but you're still going to spend some money and time doing it, no matter how simple and straightforward it is.
Shirley, did you have a question?
Yeah.
So if you have a will and there's an executor over the will, what's the purpose of the executor in probate? Yeah. What's the purpose of the executor if it's the court that oversees everything? What does the executor do?
So with a will, it's actually usually referred to as a personal representative, and but you can use that term, I think executor, it suffices. So they are the ones actually responsible for handling the estate. So if there was a house, they would sell the house. But they still have to get permission from the court to do almost everything. And they have to give an accounting to the court after the fact and show what assets were in the estate when the person passed away and what they've done with those things to ensure that they've carried out the person's desires. So if I list somebody as my personal representative and they just take all my money and leave town, the court's there to protect my heirs from that happening. And the court has my will so they can see what I wanted done. And they can then, theoretically, they would enforce those wishes.
Hang on just a sec. I do want to make sure that, some of you have kids in here. It's really important, too, to have medical documentation for those children if you have someone else who is overseeing them. So, for instance, I had a situation where Randy and I were on vacation. Our son and daughter were with my parents. He fell at Kensington and cut his chin open, and it was difficult to get care for him because they did not have a form giving them permission. So that's in a living situation. That's not even if somebody passes away. So I just wanted to mention that because that is a document that is so often overlooked for even those who it's not estate planning per se, but it can fall into that category.
Yeah, so if you go on vacation, it's very easy. You can just sign a one-page document basically giving limited power of attorney to somebody over your kids to make decisions for them while you're gone. So if something like that happens, you know they're going to be taken care of. And I think you told me in that incident, you had to somehow fax over an authorization into the emergency room or something so they could do emergency. Yeah, which is ridiculous. So, I mean, I could see why those safeguards are in place, but if you specify ahead of time what you want done, it's much easier. All things to think about.
So just back to the probate issue, you know, I have heard that probate could wind up costing a estate a very substantial portion of the estate. I'm not exactly sure why that would be. Could you speak to that?
Yeah, so actually I did a little bit of research. So I don't know how accurate this is, but there's a figure I read somewhere that probate on average, it's like ends up costing 5 to 10% of the assets in a given estate, depending. So there are, if you want an attorney, you're going to pay an attorney for their time to oversee and guide you through the process. If you file a request with the court, there's a filing fee for each thing that you want. Every time you file a document, there's a filing fee. Then there's an inventory fee. So the assets in the estate are all calculated. You have to show them all to the court. And if it's a larger estate, there's a number, there's an amount that's proportional to the value of the estate that you just have to pay the court for the privilege of dividing it up among the heirs. So that's where the majority of those costs would come from.
Well, I want to move on a little bit, and then we can touch back on any of this, but I was just really interacting with, and I had texted you earlier about Deuteronomy 8:18. And, you know, I've read this verse before a number of times, but it was just really hitting me different this time as I was reading it. And it's, you shall remember the Lord your God, for it is he who gives you the power to get wealth, that he may establish or confirm his covenant, which he swore to your fathers as it is in this day. And so when I looked up the word power in the Hebrew, it's kosh, it's Koach. And it means divine power, divine ability, substance, wealth, or divine strength to lay hold of something that is beyond our strength to lay a hold of. And I guess what I was interacting with was from an inheritance standpoint, I think oftentimes we think about the fact that we have to work really hard to build this up in order to push that forward into future generations. What I'm interacting with on this scripture is that he actually has empowered us to make a living, and even beyond that, to create wealth. He's given us divine creativity. He's given us influence. He's given us power and strength to do that. And it's really, even for the job or the purpose that we've individually been called to, the assignment that God has given to us, in that assignment, he has made provision for everything that we need. And the covenant with God is not based upon what we can do, but it's really provided to us through the finished work of Jesus Christ. And so it's no longer us taking it into our own hands to make it happen, but it's about relying on him and that finished work. And I believe what I was interacting with was when we rely on our own strength, that's when lawlessness arises. And that's really where the legal system comes into play with this. Because when our focus becomes selfish, when greed and lust enter into it, then the law is necessary to be executed to protect the innocent and also to protect the inheritance. And so what he's talking about, these different legal terms, these different things that are set into place, is really about lawlessness that was created from us believing in our own strength that we could actually create this. Are you interacting with that? I mean, it's a different thing. I used to tell my kids at the beginning of each school year, you've got all A's. All you got to do is keep them. We've been given all wealth. We've been given all inheritance. All we have to do is keep it. We have to steward it properly. We have to, that doesn't mean that there isn't work that's involved or that there isn't, times of laboring, but the fact is that he becomes our trust. He becomes that place of provision for us rather than us generating that out of ourselves. Just wonder if you want to maybe talk about that a little bit.
Yeah. I mean, when we join God's family, He's our Father. He's our provider. He becomes the one who takes care of all of our needs. We didn't have that relationship with Him before. So you can see why people who don't have that hope would be grasping for every opportunity they can. Their livelihood depends on themselves, on their ability. It's them against the whole world. And for me, like, yes, I have an obligation to get out of bed and work every day, but God gives me that ability, and then He rewards it. So it's all coming from Him no matter what. And I can know that He's going to take care of me. That I can't tell you how many times I'm at a part of the month where a big bill is coming due, and I'm thinking, what am I going to do here? And then God brings a new client in right in the nick of time. It happens so frequently. And it's a reminder of His faithfulness to us, is that He takes care of us. If we do I hate to say we do our part, because it's really us just using what He gave us. He honors that. And so, and even with salvation, God gives us the faith that we use to cling to Christ. We don't work that up in ourselves. So it's all for His glory. And I do have the first question of the catechism memorized. What is the chief end of man? To glorify God and enjoy Him forever. And it happens because He allows us to do that. He calls us into His family. He blesses us with the ability to serve Him and enjoy Him. So that's all I have to say about that.
Okay, Forrest. Okay, so I'm thinking about Luke 15, the prodigal son. And here's this prodigal who asks his father for his inheritance ahead of time. So in the Jewish culture, the inheritance was never given while the person was still living. But this prodigal asks for his inheritance, and his father grants it to him, and he spends it foolishly. Anyways, upon his return, where his father runs to him, puts his cloak upon him, gives him his shoes and his signet ring, and decides to throw a party for him, the elder son complains that he has been there the whole time. He's been the diligent one. He's been the one working hard, and the father never had a celebration for him. And the father's response to him in verse 31 of Luke 15 was, "My son, you are always with me, and everything I have is yours." And again, it's a repositioning of how we look at wealth. A lot of times we look at wealth about what we can produce. But if we look at wealth from the standpoint that everything that we have need of, everything that is in need of living life in abundance and to the fullness, in righteousness and peace and joy, is provided to us as an inheritance through the Father. That we have that, just like the elder son had that. He didn't have to work. He didn't have to be complaining. It was already his. And as the elder son in the Jewish culture, he had a double portion. He even got more than what the prodigal did. But I think it's about a repositioning, and I think our culture has caused the body of Christ to think wrongly about inheritance. I think we look at it as something that, we can scrape together and hopefully provide something for our children, but there's so much more to inheritance than just monetary. Jenny and I were talking about grandchildren earlier, and just, how when she sees her grandchildren, she will give this expression of joy so that they connect with the joy of her seeing them and their relationship together. That's an inheritance that she's giving to them. When our grandkids are with us, we're always talking about different things like, you have choices. You chose this. That might not have been a good choice, and you're constantly giving them nuggets of truth, which is also inheritance. You were talking about the mentor that you had, that, who took you on, and does a Bible study with you, and he lived his life out before you, and it became something that was enticing to you, that you wanted to be the same. So I guess I just thought about, what do you think about in reference to how can we reposition our thinking differently about inheritance? I mean, we, certainly from a legal standpoint, but even as being a good steward.
I love what you said about spiritual inheritance and how our children are beneficiaries of God's grace to us, because it is so true that the children of Christians are holy. They're given privileges and advantages in their spiritual life that other children don't have. They hear the law of God. They're part of that visible covenant community, and they get to see worship on Sundays, which is a big deal. Like, we take it for granted. That's how God calls people to himself, is through that public worship and the preaching of the gospel. So huge advantages, huge inheritance. Nothing more important to your children than their relationship with the Lord, and God provides that even for them through salvation. Regarding stewardship, yeah, I think that if we can break out of the mentality that we have in our culture of consumerism and spending what we have on ourselves and even on our families, but on the short-term stuff, even things like college, as good as those are, and think long-term about what we have and what we want our children to have and what we want their futures to look like, I think that's the way you have to proceed. Am I going to save up for my children to go to college, or am I going to raise them in a Christian school now and use that money to provide a foundation for them to have wisdom, so that when they do graduate, that they can actually, handle themselves and they don't go off to college and go off the deep end? Not saying that happens necessarily when people go to college, but the point is, having an eternal perspective, or even just a long-term perspective, is key to that. Do we want to spend all of our money, or do we want to save some for our kids? I'll talk about trust a little bit. In a trust, as opposed to a will, you can set out certain conditions for the resources that you want to leave to your family. You can specify that the trustee, which is the person in charge of distributing the assets, can only distribute them in a certain way. So if you want to leave money to your children that is given to them over time instead of all at once, there's going to be less of a temptation, like there was for the prodigal son, to just spend it all and waste it. If you have children who are younger, they're not going to be able to make decisions about what to do with money. If you want it to be used for their education only and not just flat out given to them and put into their accounts, a trust can help you with that. So that's one of the practical things that you can do, but it's the long-term viewpoint. It's the prioritizing things that are important to the Lord, and then putting in place those things that can actually bring it to pass, and not just hoping for the best. I hope that when I pass away, I'll have enough money for my children to be comfortable. Well, there might be more important things for them than comfort. Or, it might be better for them to not be given everything all at once. Warren Buffett, I think, said, I'm going to mangle the quote, but it was like, I want my children to have enough money that they feel like they can do anything, but not enough that they feel like they can do nothing, which he's limited what his children are going to inherit. They're not going to get equal portions of his entire estate for that reason. And it's the long view, because he knows what's best for them, and ultimately is that they work and that they have a purpose and that they use those resources that he's built up over the years for their children and for future generations.
I think lottery winners are a good
Perfect
example of this.
Yeah.
Because you've got people who, they've lived a life of, living from paycheck to paycheck, and all of a sudden they strike it big with this lottery. And so they decide to cash in the lump sum, and 2 years later they're claiming bankruptcy because they've given their money away, they've given it to everybody, they bought everything, they have 20, Xboxes, and, you know, but it's like the character, which you're talking about as far as really building into our children, our grandchildren, is necessary for stewardship. And I think that's one of the things that's so often overlooked, even in Christianity, is we look at gifting and we look at the skills that someone has, but we don't always look at the character by which and the integrity by which they live their lives. And if you've never received, I've received an inheritance. Both of my parents passed away, and it is something that when you're given this money, you now have a decision to make. What are you going to do with it? How are you going to steward this? And you do have to have a long-term view or an eternal view on it. Otherwise, it's very tempting. It's very tempting.
And I'm making all these statements. I'm not perfect about being a steward of the things that God has entrusted me. It's a standard that we're striving to, that we aspire to keep. Again, no one can keep the law perfectly. But yeah, sometimes I think that winning the lottery would be a judgment from the Lord, because it just creates so many problems for so many people. But yeah, that long-term eternal perspective, that's the key.
Well, I
And
think
there's proverbs about that too, right? Wealth gained hastily is squandered. I don't know the
yes.
exact
Yeah,
verse, but
sounds like a Proverbs.
right.
I want to open it up to comments, questions. Randy, if you would be so kind to maybe run the mic, but just talk with us. What's on your heart? What brought you here tonight? What were you thinking about you wanted to really interact with?
So me and my husband don't have kids yet, and so we're starting to try to plan, like we are trying to save for a house and things like that. When is the best time for, like, we both have life insurance policies, right? So it's just kind of like, there's not much to like divvy up at this point. But at this point, really, because there's no assets involved, you don't really have to do like wills or things like that. Is it normally when you have like your first child that you start to do like a will in place and things like that, and you start to like, when is kind of like a good order of events to kind of set up that way?
So I'm self-interested, I guess, in saying this, but I think everybody should have a will. If nothing else than just to specify that you want your, one of the standard provisions is that you want your, you can specify how you want your remains handled, what kind of funeral you want, if you want to be cremated or buried. Certainly when you have children, you should have one. But I recommend everybody just do a will. Even my single friends who aren't married, I suggest that they do it. Nobody follows my advice, but that's my answer to that. And then you can, like I told you, I don't have a trust. I don't think everybody necessarily needs one, but certainly a will is a good starting point. Power of attorney forms too would be relevant to you, because if something happened to you or your husband where you couldn't make decisions for yourself, you need to have a power of attorney so he can make those decisions for you, or if you wanted to name one of your parents as like a backup if something happened to both of you. If you were both in a car accident, it would be difficult, I think, for somebody to come in from outside your immediate family and try to decide what to do at the hospital without having one of those documents in place. And then, yeah, once you have kids and you have some assets, looking at a trust would potentially make sense. People are under some misconceptions about trusts, that they automatically provide creditor protection. Not all trusts actually do that. So getting into the specifics of your circumstance, you may want a specific type of trust, you may want a living trust, you may want an irrevocable trust, but those tend to be more expensive. Trusts are generally in the thousands up front in terms of getting an attorney to draft that document. We do wills for like $500. So it's a smaller upfront cost. But like I said, there's probate and everything like that at the back end of that. But just to have something in place, I think, is a good idea for everybody.
A follow-up?
Yeah, just real quick. So like if we were to get a will and like pay like an attorney to get it like figured out and everything, like then what happens with it? Is it just kept at home in the safe, or like, is it filed somewhere? So like, what happens to it when you have these papers? Like, what's the best, I don't know.
So you keep the original copy of your will. Generally, our office will retain a copy of it, not that it has any, you can't use a copy to enforce. You have to use the original signed copy. Has to be signed in front of 2 witnesses. But yeah, generally I advise my clients to keep it at home. I don't want to keep it for them. If they move or I lose contact with them, then there's going to be a problem. And then if you pass away, then that will is given to the probate court to probate, to oversee.
Good question. Shirley.
I don't know if this is, your expertise, but so I'm my mother's guardian. She's incapacitated, and her.
You are your mother's
I
guardian?
am, and her house, okay, it's only in her name, okay? My name is not on it. I was told that I couldn't do a ladybird deed on that property because it had something to do with, I don't even remember.
She
but-
owns the property?
Yeah.
Okay.
She owns the property, but I'm her guardian. My sister takes care of her. And so what's going to happen, when the Lord calls her home, the house, well, as a guardian, I'm wanting, the house to go to my sister. I know it's got to go through probate, right?
First of all, I'm going to just give a disclaimer, which I
Okay.
didn't give at the beginning. None of this constitutes legal advice, obviously. There's no attorney-client relationship. So just just
Yeah.
food for thought. And I'm happy to talk to you one-on-one afterwards. But depending on what type of guardianship arrangement you have right now, does she have a will?
She has a will.
And I assume that leaves her assets to you and your sister
Yes.
equally.
Well, there's more of us, but we're the only two, the only 2 in the will.
Yeah.
It's a very old will, so my next question was, well, as a guardian, I don't even know if I can get a will done for her because she's
Even a ladybird
incapacitated.
deed, she would have to sign.
Okay, and she's not allowed to sign anything? Okay,
But if you're her guardian, theoretically, you could, again, I don't know what kind of documents establish your guardianship, but you might be able to make decisions like that. Like if you're her power of attorney, then you would have the authority to handle quit claiming her house to your sister potentially, or signing a ladybird deed to your sister.
okay, but a power of attorney, doesn't that require her signature?
Yeah, I was thinking if she had
Oh.
one already for you.
No, we got into this late.
Well, somebody appointed you as guardian though. So
Yeah,
how
I
did-
had to go to court. I had to go to probate court,
Okay.
and nobody contended it, so, I mean, we knew nobody would.
Yeah, so I would just say, I think that your guardianship might entitle you to sign one or more of those documents for her, but I can't say
Okay.
one way or the other for sure.
Okay, thank you.
Yeah, sorry.
Good questions. Angie.
Yeah.
Real quick, just if that's not the case and the estate just passes to you and your sister, your sister could buy your share of the house and that way she would have it, and then that would potentially solve that problem. Or you could, if you inherited.
According to the will.
Yeah, because the will splits everything equally between you. So if she were to just buy, half the house from you, then she would the court would probably approve that, I would think.
So with the will, if you have changes, is the person going to be paying each time? So say you have a kid and they're in your will, and then you have another child, and then you need to incorporate them into that will, or divorce or anything like that, or you do have a child in your will and they pass, unfortunately. Like, how does that work with the will?
Yeah, so you would need to, any amendments to the will are still going to have to be executed in the same way as the original, so you still need 2 witnesses. They can't be related, or, they can't be heirs in the will. you might be able to get someone to just draft a short document amending one of the provisions instead of just redrafting the entire thing. But you're gonna pay something in it.
Okay, so the way that it works, so am I gonna draft up my will myself and then bring it to you? Or is it like you sit down together with these people?
I would
all
recommend
together?
having an attorney draft it, and then they would oversee the signing of the will, because, so with a will signing, if you want to sign a will, you have to have two witnesses, like I said, and you have to have what's called testamentary capacity. And this goes to what we were just talking about. You have to know, the person signing the will has to know generally what is in their estate and what they're doing by signing the will. And if you go to an attorney, we can ask certain questions to establish on like a record that, yes, she knows what she's doing here by signing this document. And so out of convenience sake, you could draft the will yourself, but before I oversee a signing, I'm gonna wanna review it, so I might as well just draft it for you. Does that make sense? Because there are certain provisions of a will that a court might decline to enforce if it goes against public policy.
As far as establishing a trust, is there a certain asset value where you would begin to recommend that it's worthwhile to?
So, yeah, some people like the idea of using a trust to avoid estate taxes. So right now, first of all, I think that in order to avoid the estate tax, it needs to be an irrevocable trust, not a living trust. Right now, the estate tax limit is any asset over like $11.7 million for individuals. Now, that's probably going to change under this administration. President Biden has said that he would like to lower that, and I've heard people say that it's probably going to be like half of what it is now. Most people still fall outside of that. But generally, when you have a trust done, it's called a living trust or a revocable trust. And I don't know if you know the difference, but basically it means that you can revoke that at any time, or you can change the terms of it. And so you're still kind of in control of your money. So that creditors can still come after you, come after money that's in that trust, because it's basically yours still. An irrevocable trust gives up control of your own assets to a trustee, and they're in charge of handling it. You have no say over what's used. Creditors cannot come after that money because it's essentially not yours anymore, because you're giving control of it up to a trustee. And so, yeah, and I do want to say too, I'm not an accountant, so there are certain tax issues that come up all the time for me, and I always refer my clients, even if I do estate planning advice or draft documents for them, to have everything cross-referenced with their CPA, because the tax laws are always changing, and you want to make sure you don't create problems for yourself. But yeah, the estate tax limit right now is 11 million.
So just to be clear, in a irrevocable trust, it still remains within, everything in the trust still remains in the purview of the owners who establish the trust, but the trustee becomes responsible in the death of the
Yes, so you're talking about a living trust, a revocable trust?
no, I'm
Or
talking an irrevocable.
Okay, yeah, so in an irrevocable trust, you are, the trust maker, that they call it the settlor, is giving the trustee sole authority to do what they want, and generally you cannot change that document or revoke it after you sign it. Now, that being said, there are ways in which you could go back and, under special circumstances or through special means, change that document or even revoke it. I don't know all the details of how that's done. Again, it's one of the things that an estate specialist would talk about. But I think I kind of lost your question there.
That's okay.
Yeah, they're
Well,
your assets,
yeah.
but you essentially give them up because you don't have authority to distribute them or disperse them,
Okay.
or use them, like even on yourself.
So me and my brother have talked about this for a while, and it's hard to get an answer on things like this. So my dad is not in the best of health, but when he is in a lot of debt and has a lot of just poor things surrounding his lifestyle, when that time comes, whenever that is, as a child, when we don't have any, are we going to be legally responsible for anything like that? There is no trust, there's no inheritance, there's nothing that's going to be coming our way besides his debt or
Debt,
trying to get the
yeah.
stuff out of the house. Like, what legally as children are we responsible when nothing is set up? Can anybody come after us, or is there any actual obligations that we have?
So, no will or anything set up. So he is responsible for those debts, and anything in his estate would have to go towards paying off those debts, but they're not your obligation. So if he passes, they're not gonna, those creditors can't come after your assets unless you own things like jointly with him. But yeah, it would be limited to his estate.
I was just going to mention that after my parents both passed, Randy and I recognized that our will did not include our youngest child. And at that point, she was probably in her early 30s. So we had to redraft that and include her, and yeah. So I'm just saying that, once you do a document, it's not a static document. Things change, and
I'm gonna have to update mine next month.
yeah,
So,
he's
for the same
expecting.
reason.
They're expecting their third child. So,
And
in
I
fact,
just
he was on
signed it.
baby call, so we're hoping that tonight would happen. But I was just going to say that it's not a static situation. Once you do it, it's not a done deal. Things can change, just like what you're talking about. So,
Yeah, there's a tendency
Jill's got a question.
to sign the documents and just put them away and not think about them, but you don't want to do that.
So regarding wills, for younger families, we were told when, we were young parents, to do at least the minimum of like a handwritten will, sign it, seal it. Not to take away from your profession or anything like that, but just at least to have something.
Definitely
until you
better than
get-
not having anything.
Can you give, so what we were told is just it had to be handwritten, maybe a couple of copies or whatever, and that you signed it, maybe signed the back of the envelope.
Yeah, so that's considered, they call that a holographic will, and it doesn't necessarily have to meet the stringent requirements of the two witnesses and everything, but I don't know how much faith I would put in that. So what I would do, if you want to do something yourself, and this is just me talking, and I could be not giving the best advice, but right now with my knowledge, what I would do is type up something or write something by hand, sign it, have two witnesses witness it for me. So then I'm at least satisfying those requirements. And then if somebody comes in and challenges it, you heard about the situation with Aretha Franklin. So they found like a handwritten will in the couch, and it contradicted some of the other wills. You don't want to have to deal with a dispute or a challenge if you have just a handwritten will, because then you got to get into all this evidentiary stuff, handwriting experts. Yeah. So I would still try to have two disinterested witnesses sign, watch you sign it, and then sign it themselves. Yeah.
Guardianship of the children was the primary concern.
Mm-hmm.
So I have a quick question. I had a friend a couple years back that did her own trust. She found paperwork online, filled it all out, completed it, and then filed it with the court. Is that a legitimate way of doing that? She doesn't have any large assets. It was just a matter of buttoning things up for herself.
You can certainly do that. I don't recommend people draft those documents because they are legal documents by nature, and again, you want to make sure that they comply with the law and that they are going to be enforceable. So if there's something in there that doesn't quite work, then you could run into issues later. But assuming that's not the case, yeah, there's no actual requirement that an attorney draft anything, as much as I would love for there to be one.
I know that in the case of physicians, it's felt that if you are your own doctor, you've got a fool for a doctor. I don't know how that works in the
Same
case
for
of.
attorneys.
Okay.
So regarding a power of attorney, is it possible for me to, does power of attorney have to come from the person? Like, if I wanted to make my son my power of attorney, I would have to initiate that?
Yes, because you're the one giving up the rights.
Okay, so now in the case of my mother, and I'm already her guardian, but I'm not her power of attorney, do I need power of attorney? Or is the guardianship?
I'm a little hesitant to answer that because
Okay.
I just don't know the nature of how you
Okay.
got the guardianship or what's.
What do you mean,
know
how
you
I
said-
got it?
I know you said it went through probate, but I don't know what kind of powers you were given in that guardianship.
It is, I don't know the wording either, but there's nothing,
I would want to see, if you were a
Okay.
client of mine, I would want to
Okay.
see that document that gives you
Okay.
guardianship.
okay, because it doesn't have to be renewed every year.
Okay.
Yeah.
Yeah, it sounds to me like what you're saying is that she was ruled incompetent by the court and that they gave you guardianship. So that comes with certain authorities, but I'm a little bit reluctant to tell you exactly what authorities you have.
Just aim it towards me. Okay, hi. So, for the cameras at home. Grandchildren. So, in our will, I think we just list it as all grandchildren, because it's real simple. We're just saying all of our children, divvy it up. If one of our kids dies, their kids, you know. So we're not naming every grandchild, because we keep having, I mean, like, we are fruitful and multiplying. So is,
Yeah, and actually, I think in my will I have my children named individually, and any other children that we might have, just in case I don't update it. But for their sake, I kind of want their names to be in it, you know. But yeah, it's not. You could do something like that. That's perfectly acceptable to do.
yeah, because we're in that time of life where, I mean,
Yeah.
like,
To update it every time you have a new grandchild would be challenging. Yeah, my parents don't do that either. So.
best I know, we're not planning on having any more kids, right, hon? Just checking.
All I can tell you is that when Jessica found out she wasn't in our will, it was a hurtful thing. We had to do some RTF on that, so.
When our kids found out that she hadn't got around to changing her last name, they go, are you guys married?
Not to get too scandalous, but
You know, but.
you know, you want to specify too that it's children that you have with your spouse, because you could run into issues there too.
And that's something I wanted to ask about. What if somebody is in the midst of separation or divorce, and so maybe there's shared custody? That, it seems like it would get very convoluted as to how you would create those forms and those powers and.
Yeah, I mean, if you have a will in place, more likely than not, you have your spouse listed as your personal representative or your power of attorney, your first choice. If you're going through a divorce, obviously that's probably going to change, depending on the relationship with the former spouse. So, yeah, any family issues, and there's a reason why I don't do any family law, but any of those issues are going to make things more complicated, and everything would have to be revisited.
Letitia, did you have a question? No? Go for it, Kate.
No, hang on.
Sorry, okay, so just like a follow-up random question. So if we get the will and then it's in our home safe, it's like in the fire safe and things like that, but what about when people, like the tornado comes or their house burns down and they lose everything and they don't have that document anymore? How is that, like, is it registered somewhere? Is it registered with the court where if something were to happen, that's still valid? Or
You
do
can
just have
pre-file
to-
it with the court where you live, assuming you're still going to live there.
Okay.
And then if you were to move, I think you'd be able to request it. But in general, if you lose the original is the only one that actually counts. So the copies that we give clients are just for reference so they can see what's going on. The original is the one that counts. So if you lose the original or if it's burnt in a fire, you need to have it redrafted or call the attorney. They'll probably have it saved and they can print it out and you can come in, sign it again.
Okay, thank you.
Okay, so regarding keeping the original at home, I keep all my papers in a safe deposit box.
Yeah, 'cause it's
So-
a good policy.
Yeah, but what happens, like during COVID, couldn't even get to the bank? Are there laws in place that would enable me to get a hold of those papers if something like that happened?
Yeah, I mean, generally, a court will order the bank to turn it over if you have a lot of problems getting a hold of it. Another example from one of my cases is I have that person who was in Livonia who passed away. So now his sister-in-law in Florida is trying to manage his estate. There's a bank account he has here. The bank won't talk to her. They said, you have to come in and show us your ID. She's not going to come here from Florida. So we got letters of authority from the court and we sent them to the bank, and now they're doing it. Now they're showing her what's in the account so she can close out the estate. So
Okay,
a
one last
subpoena or a
question.
court order is always
Okay.
the answer.
Okay, so one last question, might be silly. So if I've got my papers in the safe deposit box and the bank burns, I mean, is that possible?
These are like
the
law
bank would-
school level hypotheticals.
I don't know, I thought about that during COVID, you know. They-
Yeah, I think there's a
They
lot of
are,
safeguards. in-
okay. But
And
are
they're
there,
insured, so if you ran into issues because of that, they would be on the hook for any of.
okay, so there are
damage.
laws in place that my original was there. So do I need proof that my originals were in the safe deposit box? Is that
I see what you're saying,
necessary?
yeah.
Yeah,
I'm sorry, I don't know the answer to
not a
that.
problem. Okay, all right.
Yeah. But that would certainly be a question I would ask the bank. You know, I'm putting a copy of my will
Okay.
here. A lot of people keep their wills in safety deposit boxes, I'm sure. So if you were to ask them what safeguards do you have in place, can I take a picture of this in the box to prove that it was in here? That would be what I would do. I would ask the bank.
Well, I know I can take a picture of it because I can go and pull my whole box out and go through it. I have to do that every now and then.
Yeah. I don't think the bank would have any records, though, of what you have in
The
there.
bank wouldn't have a record, that's right. Okay,
Because usually those are private, so.
Okay.
But again, you could request that potentially from the bank, that they maintain a record of what you have in the box. I don't know what those policies are.
okay.
One last question? Good? We're all good? All right. Is there anything you want to leave us with? Parting comments, wisdom?
No, I really appreciate the opportunity to come and talk to you guys, and hopefully I was able to give you something to chew on, to eat the meat and spit out the bones.
You just thought it was safe.
Okay, so I see the kind of company, you're with. What is your opinion on these practices like My Lawyer, where there's are those any good?
Are you talking about like online legal
No,
services?
no, you can actually, when I've read about them, another one is called Legal Shield. Yeah.
Like legal insurance?
No, Legal Shield. Oh, okay.
I like those because we get clients from those services.
Okay.
So those organizations, if I'm understanding what you're talking about, will connect people that are covered by them to attorneys.
Okay.
Yeah,
that
so we'll
answers
get
my
clients
question.
from
Okay.
those at times.
Okay, thank you.
Yeah.
So let me leave you with this, Ephesians 1:3. Blessed be the God and Father of our Lord Jesus Christ, who has blessed us with every spiritual blessing in heavenly places in Christ. So our inheritance is laid up in heavenly places, but in the Lord's Prayer it says, on earth as it is in heaven. So we have the ability to pull down that spiritual inheritance. We have the ability to obtain and get wealth. And I just think that the body of Christ needs to be empowered by that, rather than us thinking that we have to work. We just need to trust that the Lord is going to guide us and lead us and cause us to be good stewards in order to pass on for future generations. Amen? All right. Well, Joe, thank you so much. We really appreciate all of the questions. I mean, anybody who can withstand Shirley's questions has got my vote.
Well,
So-
thank you. It was a pleasure to be here.
Just one final comment. I would just like to say, if any of you are looking for some legal work to be done, I can heartily recommend Joe. And quite honestly, you're going to be able to afford his services, because there are many attorneys who are much, much more expensive. And so I would just say that Mr. Engerer is a extremely fair with his fees, and I would heartily recommend him, and he will certainly refer you to any other specialist who is needed for certain specialized work. But you'll never go wrong by starting with a conversation with Mr. Engerer. So with that.
Thank you, I appreciate that. I do have business cards here, too.
Okay, good.